The Monongalia County Planning Commission, MCPC, goes by many different names interchangeably. Some of these names include Monongalia County Planning Commission, MCPC, Planning Office, PO, Monongalia County Planning Commission staff, MCPC staff, and staff. For the purposes of the Subdivision Guideline Toolkit and reference videos and PowerPoint presentations, we will use staff as the only convention when talking about the staff within the planning office. We will use MCPC when talking about the ruling body of the Monongalia County Planning Commission, which is represented by seats within all jurisdictions within Monongalia County. We will use county when talking about everyone or thing within Monongalia County, including but not limited to the citizens, the businesses, the traffic, and the stormwater management of Monongalia County, as well as the staff and the MCPC.
What is a subdivision? A subdivision is the splitting of one or more parcels into additional parcels. It refers to the actual act of subdivision of land, opposed to a residential subdivision, which is a land or housing type, although they are related. Within the Subdivision Ordinance, there are three types of subdivision. An exempt subdivision, which is parcel divisions that are exempt from the technical aspects of the ordinance. There are 8 types of exempt subdivisions: family, cemetery, agricultural, or other resource extraction subdivisions, division of land pursuant of a court order, minor boundary adjustment, merger, or the creation of a utility or emergency services parcel. Note, according to West Virginia law, no subdivision can be declared exempt unless the MCPC or its designated staff determines that it qualifies. A minor subdivision, which is parcel divisions into 5 or fewer parcels, including the parent parcel, and that do not include off-tract infrastructure. A major subdivision, which is parcel divisions into more than 5 parcels, or that do not meet the exempt or minor subdivision requirement. Generally speaking, there are 4 types of building classifications associated with subdivisions. Residential subdivisions, which include mobile home parks, single-family homes, townhomes, apartments, and condos, or multiplexes. Commercial, which include malls, office complexes, and retail centers. Or industrial or manufacturing, which include business or industrial parks. And mixed use, which includes some combination of the other 3. Note that for a preferred design may undertake an NIF1 also before technical review is completed by staff. This is called a site work plan. This allows the applicant to begin work on site in areas that are not under review by outside entities like DOH or NUB. However, it does not allow the developer to begin construction or sell lots, but it does allow for a demolition, underground infrastructure work, grading, and other outside site work. Apart from getting a head start, it has the additional advantage of allowing the developer better site knowledge, e.g., finding a huge boulder that forces moving an internal road 5 foot, which would modify the design slightly before recording the plat. This avoids having to go through additional process of recording a new plat and possibly having to re-review the application as a whole because of such an on-site discovery. With an NIF1, the staff still has 30 days to complete the tech review after all materials have been submitted. Because a lot of time can pass between approval and recording of a plat with a major, particularly a multi-phase subdivision, changes may need to happen between. Consider the example earlier where a developer needs to make a small change based on discovery during site work. For smaller changes, an applicant does not necessarily have to start over. We will show what qualifies as a smaller shortly. An amendment is similar to this kind of change, but it occurs after a plat has been recorded and pertains to the process for changing the plat as well. So what constitutes as a smaller change? If changes are made de minimis, minor, e.g. merging of 2 lots out of 40, staff can authorize that the applicant may have to modify the recorded plat, i.e. an amendment. If changes are limited, e.g. moving a roadway 10 feet, then the applicant, staff, can authorize, with confirmation from the MCPC, again making appropriate as-needed changes to the recorded plat. However, a full public hearing is not required. If changes are substantial, i.e. major, then the applicant must redo a full subdivision review. For a complete list of thresholds between these classifications of changes, see Article 8 out of the ordinance.